coming today. This is sadly the final Federalist Society event of the year. This has been an incredibly active year for the Federalist Society. This is our 12th event, and that is in large part thanks to our fantastic vice presidents. Let's see, I know James Nolan is here. If he would just stand up if, well, maybe he just walked outside the room. But in any event, James Nolan, David Jetter, and Amy Young are two L's who are vice presidents of the Federalist Society. And thanks to them, we brought in an impressive list of speakers and the speaker today. We started off by bringing in two former Solicitor Generals, one of whom is a Duke Law professor but still has to take quite a drive to get here. Those are Charles Freed of Harvard Law and Walter Dellinger. We then had Professor John Norton Moore of UVA Law come and speak about the importance of democracy to national security. We also had Chief Judge Walker of the Second Circuit Court of Appeals come and talk about judicial confirmations. We also had Michael Grieva of the American Enterprise Institute debate Professor Christopher Schrader about attorney generals in the states and whether they're a problem or a peril. This semester, we've had Randy Barnett discuss his recent argument before the Supreme Court about medical marijuana. We've had Chief Judge Dinell Taha of the 10th Circuit come and talk about the role of international law in judicial decision-making. We've had Professor Amy Wax of University of Pennsylvania debate Erwin Chemerinsky of Duke Law School about how to think about blaming the victim and the role of race in the United States. We've also had Professor Stefanos Bibas of the University of Iowa debate Sarah Beale about Justice Antonin Scalia's sudden fondness for criminal defendants. We've also had the Assistant Secretary for the Department of Homeland Security, Stuart Verdery, talk about the nature of immigration in the United States after the dismantlement of the Immigration and Naturalization Service. And then we also, just last week, had 2 speakers. One was Erwin Chemerinsky again, talking about the recent unpleasantness of the Terry Schiavo incident and case, as well as a presentation by noted race scholar Abigail Thernstrom of the Manhattan Institute. And then today we have someone who is a frequent visitor at Duke Law School, a member of the Board of Visitors, although he graduated from our very good school, but a rival school, University of North Carolina. He attended undergrad as well as law school there, and was in private practice for a number of years before, in 1985, being appointed to the Western District of North Carolina by President Reagan as a district judge. And then in 1987, filling the seat vacated by now Justice Antonin Scalia on the D.C. Circuit Court of Appeals. Please give a warm hand in welcoming someone who will talk about a field in which he is very familiar, national security and the changing role of the courts, Judge David Sentelle.
I came in feeling a little intimidated to start with. A few years ago, I came down to speak to the Duke Federalists. They invited me down to speak on the subject of racial gerrymandering, and Robbie Everett was in the audience. Robinson Everett, as some of you may know, was the leading authority on the subject of racial gerrymandering. Today, I've been invited down to speak on national security, the changing role of the courts, and I see sitting at the back of the room my very dear friend Scott Silliman, who is certainly one of the leading authorities on the field of national security. So I know that if I get something wrong, there'll be somebody in the audience who knows it and is likely to let me know about that later on, or perhaps today. Then, as intimidated as I already was when I heard the list of the speakers that you've heard this year, I wondered if you had made a bad choice by extending it one more meeting. Perhaps it would have been good to quit while you were ahead, although I must confess I'm not sure I would have wanted to attend and heard one more presentation on the Schiavo event. I quit listening to news radio by the fact that it seemed that no one knew anything was happening in the world except that. In that tragic incident, the only bright side, I suppose, was it knocked Michael Jackson's case off of the headlines for a few days. Well, national security has more to do with our personal lives than either of those. And as far as the role of the courts, the 3 branches of government, the executive, the legislative, and the judicial, create a triangle that makes our system strong. And of those 3 branches, both the executive and the legislative have long claimed substantial roles in the defense of national security. The judiciary has long had a role as well. Sometimes it's been an important role. For example, domestic intelligence gathering in national security matters depends upon the order of the Foreign Intelligence Surveillance Court, acting under the Foreign Intelligence Surveillance Act, 50 U.S.C. Section 1801 et seq. Sometimes, as long ago as the Adams administration, the courts have passed on the very existence of a state of war. In the case of Bass v. Tingey, which some pronounce Ba v. Tingey, but I can't get over saying Bass v. Tingey, 4 U.S. 37, 1800, the court passed on the very existence of whether the country was at war or not. And that has the distinction of being one of the very few important cases before John Marshall came on the Supreme Court. But more often, the role of the courts in national security has been to defer to the other two branches. But on June the 28th of 2004, the Supreme Court issued 3 anxiously awaited decisions in cases involving issues of national security law. One of those decisions, Rumsfeld versus Padilla, 124 S. Court at 2711, turned out to be a procedural decision, very narrow, not much precedential importance. But the other two, Hamdi versus Rumsfeld, 124 Supreme Court 2633, and Rasul v. Bush, and by the way, you'll hear that pronounced Rasul, and Rasul, and probably a few other ways, so I just say whichever one comes to mind as I go by it. That one, taken together with Hamdi, fundamentally redefined the role of the courts in the arena of national security. I'm going to discuss them in what may seem an illogical order. I'm going to start with the later case, but it's only 53 pages later, so that doesn't make much difference. Rasul was the more startling of the two. It also encompasses much of what is relevant about both opinions, so I'll discuss it first and intersperse a little abbreviated commentary about the decision in Hamdi. Because if you take Rasul as the starting point, Hamdi is not very surprising. In Rasul, the court considered what it stated as the narrow but important question whether the United States courts lacked jurisdiction to consider challenges to the legality of the detention of foreign nationals captured abroad in connection with hostilities and incarcerated at Guantanamo Bay Naval Base, Cuba. Well, in that case, the court reviewed a decision of the District of Columbia Circuit, the circuit on which I sit, although I was not on that panel, Al-Oda versus United States, 321 F. 3rd, 1134. The circuit had affirmed a district court decision that had the Rasul designation, Rasul v. Bush, 215 F. 2nd, 55. That controversy arose on the petition for habeas corpus of next friends for Australian and Kuwaiti citizens who were held at Guantanamo Bay. The district court had dismissed the case for lack of jurisdiction. The district court held, and my circuit affirmed, that there was no jurisdiction. The district court's opinion and the Court of Appeals affirmance rested principally on a venerable precedent of Johnson v. Eisentrager, 339 U.S. 763, a 1950 decision. The court's reliance on that decision was in all ways reasonable. Indeed, it was expected, given that for 54 years that was generally regarded as stating the law on the subject of the jurisdiction of the courts to issue writs for aliens detained outside the sovereign territory of the United States. Generally, nothing else appearing, there was none. Eisentrager arose in the District of Columbia when 21 German nationals petitioned the district court for writs of habeas corpus. The Eisentrager petitioners had been convicted by military commission at Nanking, China, for engaging in, permitting, or ordering continued military activity against the United States after the surrender of Germany and before the surrender of Japan. Now, because during that interim period, the United States and Germany were no longer at war, hostile acts against the United States by German citizens, such as the petitioners, were violations of the law of war. The petitioners were all arrested in the China theater. They were tried in China. They were repatriated to Germany to serve their sentences in a prison in Germany, but under the command of the United States Army. Never in the course of events did any of those aliens enter the United States, and certainly they were not held in the United States. The petitioners sought orders from the district court for the production of the body, habeas corpus, for the purpose of inquiring into the legality of their confinement, which they alleged was in violation of various provisions of the Constitution and laws of the United States and provisions of a Geneva Convention. The district court dismissed the petition of Eisentrager on behalf of himself and the others for lack of jurisdiction. They cited the then recent Supreme Court decision in Ahrens v. Clark, 335 U.S. 188. The district court, like the Supreme Court in Ahrens, that's A-H-R-E-N-S, was construing the statute 28 U.S.C. section 452. That's a predecessor statute to 28 U.S.C. 2241, which now governs that sort of habeas proceeding. The statute stated, the several judges of the district courts within their respective jurisdictions shall have power to grant writs of habeas corpus. Now the question for the district court was whether it had jurisdiction to entertain a petition for a writ on behalf of aliens who were neither confined nor convicted in the district of the court, and whose custodians likewise were beyond the geographic boundaries of the district in which the court sat. The district court held that the jurisdictional statute granted it no such jurisdiction and dismissed the writ. The petitioners appealed. The Court of Appeals disagreed in that case. The Court of Appeals, and this was long before I sat on the court, so I take no responsibility for this. The Court of Appeals read Ahrens as having left open the governing questions of the controversy before it, and held that the court must answer these questions. Are these petitioners entitled to the writ as a matter of substantive right? Second, if a federal jurisdictional statute deprived them of that privilege. Third, if they are entitled to the writ and cannot be deprived of the privilege, in what court does their petition lie? And they and their immediate jailer being outside the territorial jurisdiction of the district court. Now, if that sounds backward to some of you who've read more recent Supreme Court decisions, like the Steel Company case, it is backward, because the court started with the substantive right and then said, well, the jurisdictional statute can't take it away. That's not the way we analyze things generally, and not the way the Supreme Court says to. You start with your jurisdiction, and if you don't have jurisdiction, you don't know whether there's a substantive right or not, because you have never gotten to that question. But the Court of Appeals started backward on that one, and they ruled that the case was not governed by Ahrens, the jurisdictional question, because they answered the first question by saying, yes, there is a right of habeas corpus that's an inherent common law right. Then they answered the second by saying a jurisdictional statute could not deprive anyone of a right, which would otherwise be their fundamental right, because of the section in Article 1 of the Constitution that the federal government cannot suspend the privilege of habeas corpus except when in rebellion or invasion the public safety may require. Now, pause to note that the way they answered that second question was probably dictated by the way the court framed the issue, which was to get it backward. But as to the third issue, the court reasoned that Congress could not effectuate by omission that which it could not accomplish by affirmative action if the existing jurisdictional act had the effect of depriving a person entitled to the writ of his substantive right, then that act would be unconstitutional. Therefore, the court would construe it to avoid that result. So it dispensed with the formal stricture, what it called a formal stricture, that courts created by written law and whose jurisdiction is defined by written law cannot transcend that jurisdiction. I remind you again, I was not on our court in those days, and I take no blame for that. By reasoning that way, they applied that stricture to the question before them, said they couldn't uphold that jurisdictional statute unless they construed it so as to give the district court jurisdiction. They said the district court would have jurisdiction over superior officers of the custodians in Germany in the Army. Therefore, they reversed the district court's dismissal of the petition, The Secretary of Defense became the relevant official. He sought certiorari from the Supreme Court. You already know the Supreme Court granted it because I gave you a Supreme Court citation to Johnson versus Eisentrager. And in the Supreme Court, Justice Jackson, for a 6-justice majority, in a characteristically lengthy Justice Jackson opinion, reversed the Court of Appeals. In the introduction to his reasoning, Jackson noted that we are cited to no instance where a court in this or any other country where the writ is known has issued it on behalf of an alien enemy who at no relevant time and in no stage of his captivity has been within its territorial jurisdiction. Now, very briefly put, the court went on to hold that without citizenship and without presence in the jurisdiction, the entitlement upon which the Court of Appeals based its reasoning was illusory. Although the United States had extended constitutional protection to friendly aliens within our sovereign territory, the same is not true of enemy aliens. A resident enemy alien is constitutionally subject to summary arrest, internment, and deportation whenever a declared war exists. The court went on to declare in no uncertain terms that the writ was unavailable to enemy aliens beyond the sovereign territory. It noted that trials of the writ, and you'll hear this phrase 2 or 3 more times before I get through, trials of the writ would hamper the war effort and bring aid and comfort to the enemy. The court further noted that such trial would constitute effective fettering of a field commander by allowing the very enemies he is ordered to reduce to submission to call him into account in his own civil courts and devote his efforts and attention from the military offensive abroad to the legal defensive at home. The Eisentrager court went on to declare that the decision of the Court of Appeals would extend the coverage of the Constitution to non-resident enemy aliens, which is denied to resident enemy aliens. Resident aliens, the court declared, are entitled only to judicial hearings to determine that they are in fact enemy aliens. Once that's established, those resident here may be deprived of liberty by executive action without hearing. And they cited an old case to that effect, Luddick v. Watkins. Finally, the court concluded that military authorities had jurisdiction to accuse, try, and condemn the enemy aliens petitioning the court. While the court reversed the decision of the Court of Appeals that had vacated the decision of the district court, the High Court did note that the district court did not need to rely on Aarons v. Clark, and that became important later. But that case, along with Ex parte Endo, which was cited in the Supreme Court, dealt with persons residing and detained within the United States. The only question asked in those cases was where those persons might invoke federal process. The question in Eisentrager was not where, but whether. To recapitulate, in Eisentrager, the court held that the military had jurisdiction to confine, accuse, try, and condemn enemy aliens. The courts of the United States had no jurisdiction to entertain writs of habeas corpus where the aliens were beyond the sovereign territory of the United States. And even as to enemy aliens within the United States, the justiciable right of the aliens extended only to the judicial establishment of alien enemy status. And so stood the law from the time of Eisentrager in June of 1950 until June of 2004, June 28. And on that day, a deeply divided Supreme Court rendered Rasul v. Bush, in which the court, and I'm going to commit the cardinal sin of quoting the unofficial syllabus, but it says it pretty well, held that United States courts have jurisdiction to consider challenges to the legality of the detention of foreign nationals captured abroad in connection with hostilities and incarcerated at Guantanamo Bay. Now, in fairness to Justice Stevens and the 4 other justices who joined the majority, he put the question a little differently. He said the question is only whether the federal courts have jurisdiction to determine the legality of the executive's potentially indefinite detention of individuals who claim to be fully innocent of wrongdoing. Then he said, having answered that question, the court reverses the judgment of the Court of Appeals and remands for the district court to consider in the first instance the merits of the petitioner's claim. We've established jurisdiction, they said, now it's to the merits. In Rasul, the petitioners were 14 aliens. Now, they were not from enemy nations, but they were captured in Afghanistan during hostilities between the U.S. and the Taliban. The U.S. transported them to the naval base at Guantanamo Bay on the southeast coast of Cuba, which the United States holds under a 1903 lease specifying that the United States recognizes the continuance of the adamant sovereignty of the Republic of Cuba over the leased areas. They quoted that in the Supreme Court opinion. The habeas prisoners were foreign nationals. They were not from nations currently in a state of war with the U.S., taken by the U.S. military, transported to locations outside the sovereign territory of the United States, which sounds an awful lot like Eisentrager. As I said, nobody was surprised when my court and the district court said Eisentrager governs, there's no jurisdiction. But a panel of my court having ringingly agreed, and Judge Randolph having written for a unanimous panel that no court in this country has jurisdiction to grant habeas relief under 28 U.S.C. 2241 to the Guantanamo Bay detainees, even if they've not been adjudicated enemies. My court called that the heart of Eisentrager, that the writ cannot be made available to aliens abroad when basic constitutional protections are not. But after the petition went to the Supreme Court and they granted it, the Supreme Court didn't agree. The District Court and the Court of Appeals agreed to the proposition I advanced a few minutes ago that the relevant facts of Rasul are indistinguishable from those in Eisentrager. Now, 3 justices of the Supreme Court accepted that proposition, that there was no difference in relevant fact. Scalia's dissent was joined by Chief Justice Rehnquist and Justice Thomas. Now, Justice Kennedy, who concurred with the majority in result, but in a very different opinion, saw 2 critical differences between the facts in Eisentrager and the facts before the court in Rasul. Now, we're going to come back to that in a few minutes, the concurrence and the dissent, after we take a look at the majority. Now, let me note first that it is a true majority. Justice Stevens wrote for himself, O'Connor, Souter, Ginsburg, and Breyer. They don't need Justice Kennedy. If they did, this case might not be as significant as it is, because his opinion doesn't seem to reach as far in implication as does the majority's. But it is a majority. They don't need Kennedy. And to proceed with the examination of the majority's reasoning, the court stated that the consolidated cases in the Rasul decision present that narrow but important question whether the United States courts lack jurisdiction to consider challenges to the legality of the detention of foreign nationals captured abroad in connection with hostilities and incarcerated at the Guantanamo Naval Base. As I stated, the court said yes. What did the court do with Eisentrager? Well, it dispensed with that venerable precedent by reciting 6 factors that were set out in Eisentrager at page 777 and Rasul at 2693. And that being that to support that assumption, that is, that the prisoners are entitled to constitutional right to sue in some court of the United States for a writ, we must hold that a prisoner of our military authorities is constitutionally entitled to the writ, even though he is 1, an enemy alien, 2, has never been in or resided in the U.S., 3, was captured outside of our territory and there held in military custody as a prisoner of war, 4, was tried and convicted by a military commission sitting outside the U.S., 5, for offenses against the law of war committed outside the U.S., and 6, is at all times imprisoned outside the U.S. Now, the distinction between the petitioners in Rasul and Eisentrager is real but not immediately apparent. The court, however, made it clear that the petitioners before it differed from the Eisentrager detainees in that they are not nationals of countries at war with the U.S. That's not technically correct, perhaps, because Germany had surrendered, but at best it's a technical distinction. The Eisentrager detainees were Germans. Germany had been at war with the United States, and Germany was an ally of Japan. Eisentrager detainees therefore differed from the Australian and Kuwaiti nationals involved in Rasul. The second distinction, however, that the majority saw from Eisentrager was that the earlier court, the Eisentrager court, was dealing primarily with constitutional jurisdiction. and had little to say about the petitioner's statutory entitlement to habeas review. As to that distinction, I'm withholding my comments, and I will give you those of the dissent a little later. It's a distinction the majority saw as critical. In the view of the majority, the Eisentrager court was principally concerned with constitutional, what the circuit court in Eisentrager had called fundamental matters. And that's on the theory of the Rasul court that the current state of statutory law in Eisentrager left the courts nowhere else to go. More specifically, the review of the Rasul majority was that the Aaron's decision had created a statutory gap which the Court of Appeals in Eisentrager had seen as an unconstitutional gap to be filled by reference to fundamentals. Aside, you'll remember the Eisentrager court said you don't need to rely on Aaron's, but Rasul court saw that differently. The Supreme Court in Eisentrager thought that the Aaron's decision controlled as to statutory jurisdiction according to the Rasul court, but did not agree with the Court of Appeals that the gap was unconstitutional. So the Rasul court treats the Aaron's analysis as being essential to the decision in Eisentrager, and it then held that Aaron's had been overruled by Braden versus 30th Judicial Circuit of Kentucky, in which, according to the Rasul court, the Supreme Court held that contrary to Aaron's, a prisoner's presence within the territorial jurisdiction of the district court is not an invariable prerequisite to the exercise of district court jurisdiction of the federal habeas statute. The Rasul court went on to reason that because Braden overruled the statutory predicate of Eisentrager, therefore Eisentrager no longer compels a holding that the courts lack jurisdiction to issue the writ. So the Rasul court held that the habeas statute does extend geographically to the base at which the prisoners were held in Guantanamo. At common law, the court says, courts exercised habeas jurisdiction over the claims of aliens detained within sovereign territory of the realm. And they go back to cite Lord Mansfield from 1759 to that effect. So the majority said there was no doubt that the court's power to issue writs of habeas corpus existed if the territory was under the subjection of the Crown, in Mansfield's words. So the court went on to say that no one questioned the district court's jurisdiction over custodian of the petitioners, ultimate authorities of the custodian, the superior officers, and therefore they held that Section 2241 confers on the district court jurisdiction to hear petitioners' habeas challenges to the legality of their detention at the Guantanamo Bay Naval Base. Now, Justice Kennedy agreed with the ultimate conclusion that the district court could exercise jurisdiction to hear the petitions for the writ of habeas corpus by the aliens held at Guantanamo Bay. But he found it a much closer question than the majority did, and he seems much more disturbed by the result. I didn't hear the speech on Justice Kennedy's recent friendship for criminal defendants, but he seemed very disturbed by the result he was reaching here. He began by agreeing with the dissent, and we'll discuss the dissent a little bit more in a moment, that the majority's reasoning had an exposed weakness in its premise that Baden overruled the Eisentrager holding. Kennedy agreed with the dissent that the court's approach simply was not a plausible reading either of Baden or of Johnson v. Eisentrager. He saw in Eisentrager a backdrop of constitutionally commanded separation of powers that was not given much importance by the majority. In Kennedy's view, the Eisentrager petition, the 1950 case, was not within the proper realm of judicial power. Rather, it concerned matters within the exclusive province of the executive or the executive and Congress to determine. So again, he was looking back to the traditional role of the courts in national security, which most of the time is to defer to the political branches. He went on to observe that the Eisentrager court had noted an ascending scale of rights that courts have recognized for individuals depending upon their connection to the United States. He quoted Eisentrager to put citizenship at the top of the scale, but he recognized in Eisentrager respect for essential pattern for seasonal executive constraint of enemy aliens. He noted the importance of the place of detention to the jurisdictional question in Eisentrager, and that the older court had observed that physical presence in the United States implied protection. Among other considerations that he found in the Eisentrager opinion that were not discussed in Rasul were that the earlier court had considered the extent to which jurisdiction would hamper the war effort and would bring aid and comfort to the enemy. I told you we'd come back to that phrase. We find it again there in Kennedy. In that connection, he recalled that the earlier court had concluded that because the existence of jurisdiction would have a clear harmful effect on the nation's military affairs, the matter was appropriately left to the executive branch, and there was no jurisdiction for the courts to hear petitioners' claims. In Kennedy's view, the decision in Eisentrager indicated that there is a realm of political authority over military affairs where the judicial power may not enter. Recognition of that realm acknowledges the power of the President as Commander-in-Chief and the joint role of the President and Congress in the conduct of military affairs. However, Kennedy believes that it is possible, indeed necessary, for the court to exercise jurisdiction under appropriate facts to protect persons from unlawful detention, even where military affairs are implicated. He goes all the way back to Ex parte Milligan at the end of the Civil War for the precedent for what he's saying there. And he would have the courts exercise that jurisdiction on the Rasul facts because he sees those facts as distinguishable from Eisentrager in two critical ways. First, he finds it important that Guantanamo Bay is in every practical sense a United States territory and one far removed from hostilities. Second, he raises what is to me the most important distinction between Rasul v. Bush and the earlier military prisoners who had petitioned the court. That is, he notes that the Guantanamo Bay detainees are being held indefinitely and lack the benefit of any legal proceeding to determine their status. The Eisentrager prisoners had been tried and convicted by military commission of violating laws of war. They had been sentenced to defined terms. The Rasul prisoners had had no adjudication, and there was no way of determining their period of prospective detention. As Justice Kennedy noted, as the period of detention stretches from months to years, the case for continued detention to meet military exigencies becomes weaker. I will digress at this point, but just a short way. At various places within both the Hamdi and Rasul litigations, the court and the government refer to detaining enemy combatants for the duration of hostilities. Now, the difficulty with that ancient measuring standard to contemporary detentions is perhaps best expressed in a question: how do we know when the hostilities are over? The Hamdi opinion discusses the problem at greater length. The detention of the enemy combatants in the current conflict is unlike that of detainees in previous wars. So running off to Hamdi for a moment, while in a sense the detention of enemy combatants during World War II was indefinite while that war was being fought, quoting Hamdi at page 2641, there is a distinct difference. In the current war, I'm not quoting anymore, in the current war on terror, the national security opinions are crucially important, but they're broad and malleable. Even the government concedes that given the unconventional nature, the current conflict is unlikely to end with a formal ceasefire agreement. When our nation has been fighting an enemy nation, we've known when the war was over. A ceasefire will be formalized, a surrender accepted, a treaty entered, but how will we know when the war on terror has ended? The detention of the Guantanamo detainees and of Hamdi's is indefinite in a sense not experienced by prisoners of conventional wars. The short concurrence of Justice Kennedy makes it apparent that he notes that distinction, and he places considerable emphasis on that critical distinction. Coming back to the concurrence in a moment, but now look at the dissent. I said at the beginning that Rasul presents a departure from the general understanding among judges of the law of habeas corpus as applied to enemy aliens in extraterritorial confinement, at least since 1950. The majority in Rasul may have rejected that proposition, but Kennedy in Concurrence seems to accept it, and Justice Scalia for himself, Chief Justice Rehnquist, and Justice Thomas announce it out loud. In an analysis with which Kennedy agrees, the dissenters dispose of the idea that Ahrens has been overruled by Braden with little difficulty. As Justice Scalia puts it, Braden stands for the proposition, and only the proposition, that where a prisoner is in custody in multiple jurisdictions within the U.S., he may seek a writ of habeas corpus in a jurisdiction in which he suffers legal confinement, though not physical confinement, if his challenge is to that legal confinement. Therefore, outside that class of cases, Braden did not question the general rule of Ahrens, much less the rule of Eisentrager. Thus, if Ahrens is overruled, it's overruled by the majority in Rasul, not by the Braden case. Therefore, the majority is overruling Eisentrager. It's extending the statute for the first time, the habeas statute, for the first time, to aliens held beyond the sovereign territory of the United States and beyond the territorial jurisdiction of its courts. That's Scalia's dissent. The dissent further notes that there is no precedent for the extension of federal court jurisdiction to Guantanamo Bay. Now, Justice Kennedy, in Concurrence, had found the separation of powers concerns important, but he didn't find them controlling. Justice Scalia finds that concern more important. He quotes at length from what he calls the dire warning of a more circumspect court in Eisentrager. I won't read you the full warning again, because again it's those same words, that it would mean that the Army would have to transport the prisoners across the seas. That would take away shipping space. It would require the guarding of personnel, billeting, and rations. It would require transportation of witnesses. It would require the field commander to divert his attention from the offensive war to the defense of litigation at home. Now, the majority in Rasul may not state that much has changed in the balance of powers between the judiciary and the political branches with respect to national security, but Justice Kennedy in Concurrence and Justices Scalia, Rehnquist, and Thomas in dissent, I think, established that much has changed, for better or for worse. Justice Kennedy thinks that circumstances warrant a change, though he finds it disturbing. He finds it a difficult case. The dissenters find it so disturbing that they don't think it's worthy of change. Perhaps if the place of detention had been somewhere other than Guantanamo, Justice Kennedy may have voted with the dissenters. You don't know which concern is the tipping concern. Perhaps the concern for indefinite periods of confinement would not have been enough to cause him to cast his lot with the majority. We don't know. We know, as he reminds us, that there has been a realm of political authority over military affairs where the judicial power has not entered. I don't suggest that the acknowledgement of the power of the President as Commander-in-Chief and the joint role of the President and Congress in the conduct of military affairs has been wiped out by Rasul, or even by Rasul and Hamdi together. But I think Justice Kennedy and the dissent make it very plain that it has been diminished. It has been invaded. Whether this is a good thing or a bad thing will be a subject of long debate, but it's a real thing, and I think that's indisputable. I'm not going to undertake the kind of detailed analysis of Hamdi that I devoted to Rasul. The change of Hamdi is not as great or surprising. According to the opinions in Hamdi, the petitioner was an American citizen, classified as an enemy combatant for allegedly taking up arms on the side of the Taliban against the U.S. during the Afghan conflict. He was detained at a naval brig at Charleston. At the time of the litigation, the majority of the court, fragmented in opinion, so that you don't actually have a majority rationale, concluded that though Congress had authorized the detention of combatants in the narrow circumstances alleged in Hamdi, due process demanded the citizen held in the United States as an enemy combatant be given a meaningful opportunity to contest the factual basis for that detention before a neutral decision maker. Two of the justices in the majority, Justices Souter and Ginsburg, would have concluded that the detention was not authorized, but they joined the plurality that said it was in order to create a majority result. Two dissenters, Justice Scalia and Stevens, would have held Hamdi's detention to be unlawful. Justice Thomas, dissenting alone, would have ruled that in times of war and grave public danger, the president's power to detain enemy combatants legitimized Hamdi's confinement. All the fragmented opinions, except perhaps that of Thomas, either to a greater or lesser degree, represent at least some form of departure from a fairly common understanding of the precedent in Ex parte Quirin, which had held United States citizens subject to trials and punishment by a military tribunal for espionage, and held that citizenship did not change the result. Hamdi is an important decision then. It is a departure from at least one understanding of precedent, but its precise force, since it was a plurality and not a majority, will await testing and further litigation. Now, Rasul is not a plurality. It's a majority. We can know with a degree of certainty what it holds. Within the separation of powers created by the Constitution, there has long been presumed to be a citadel of executive power and joint executive and legislative power, as described by Kennedy and by the dissenters. Again, I'm not alarmist enough to suggest it's gone. I reassert that it is diminished. We in the judiciary are now involved in the conflict between the president exercising his commander-in-chief power on the one hand and enemy combatants on the others in ways that most of us would never have thought we would be. The district court, from which my circuit hears the appeals, now has entered 2 decisions, 3 if you count the military tribunal decision, dealing with the rights of these prisoners to bring these detainees to bring these habeas corpus. Judge Green took a consolidated group of cases from several district judges, and she held that the prisoners' rights have been violated, granted the writ, and has stayed her decision pending an appeal to our court. Judge Richard Leon, declined to participate in the consolidation of cases before Senior Judge Green entered his own decision, saying, okay, the Supreme Court says they have a procedural right, but there's no substantive right that's been violated. Those cases have been scheduled for a day certain, same day in the fall, so that we don't get 2 panels coming out with 2 different decisions. I can say without fear of anyone arguing with me that I don't know who the panel is for that day, so I don't know whether I'll be there or not. There's been an intervening decision about the legality of the military tribunals involved, which was argued last week before a panel that I was not on, so that decision is now within the bosom of 3 of my colleagues. At this point in time, there are more questions than there are answers, but there is a definite new role, changed role of the courts in national security. This may be a good thing, it may be a bad thing, but for the judiciary, it is a new thing. And that's all I can say about it at this time. Thank you.
We have a few more minutes if anyone would like to ask any questions about either the topic, or if you have questions for Judge Sentelle on another topic, I'm sure he'd be glad to answer them.
Depends on what the topic is. I'll be glad to answer questions about NCAA basketball if anybody is. Yes.
I have a question, but it is off topic. I wondered, either in your judicial capacity or as an observer of national security policy, if you have any concern over the ways in which national security information and intelligence in particular are allegedly being manipulated by either side of the political branches, whether that gives rise to any concerns that not relevant to this case, obviously.
That's a more political question than I really think I should answer. No matter what I say on that one, it's going to be taken to have more political implication than an Article 3 judge really ought to have. Yes.
I was wondering how much of this new role that you argue the judiciary has in national security is dictated by the definition of being at war that we have, that's probably outdated at this point, given that we haven't been officially at war in, 60 some odd years?
Well, that depends on defining at war. You're talking about having declared war. Now, going back to the Bass v. Tingey decision during the John Adams, the first administration, the Supreme Court first had before it the question of whether we can be at war without a declaration of war. The question there was whether France was an enemy Justice Washington, Bushrod Washington, among others, said, well, they're shooting at each other. If that's not an enemy, I don't know what is. Justice Washington expressed the concept of the perfect and imperfect war, and I think established 205 years ago that we can be at war without a declaration of war. And we've only had 5 declared wars. We've had a lot more wars than that. And each of the times that matter as a war, there's been some sort of congressional authorization, the use of force authorization that Bush is acting under now, use of military force authorization. The Tonkin Bay Resolution in Vietnam, United Nations Authority in Korea. So we've been at war many times that we've not had a declared war. So I don't think that distinction is important, except for the fact that by not having a defined national enemy, it's going to be extremely difficult to say when that war is over. When does the state of war end? And I think the question that you come back to is the one that Kennedy was concerned about, and which I think was certainly one of the things that tipped him, along with the geographic question of Guantanamo, and that is, how do you deal with detention during a war that doesn't have an easily definable cessation? It's not so much being at war as it is this new kind of war. How do we know when it's over? Yes.
Certainly, it's not the first time the Supreme Court has sort of changed the way it's gone, and so I was wondering what you would think about the rationale that times change, and in the years since those first decisions, we've started to realize what a travesty the Korematsu decision was, and that is why the court has gone this way this time.
Well, you still find defenders of the Korematsu displacement. Of course, you don't find very many of them anymore. Korematsu was an odd decision for somebody like Hugo Black to have participated in. But I guess it is on the mind of current justices that the court did some things during states of war that it might not have been very happy about when it looked back at them. Rehnquist, taking a broader view in All the Laws But One, his book, expresses the view that during time of war, we pretty much always give up some of our rights, and after the war is over, we pretty much always get them back. But you may be correct that they looked at some of the past mistakes influenced by state of war, and that it may have pushed them in the direction. They certainly did not say so, however. And I'm very reluctant to go behind a decision and try to decide why a court decided something beyond what it said was its rationale. Particularly a court that reviews my work, You got to be careful what you say about your professor. And yes.
I'm curious as to what extent our treaty obligations form a substantive legal backdrop to these decisions, in addition to the Habeas Act and to constitutional rights. Does the Geneva Convention, for example, require that there be some sort of hearing or due process to determine whether the Geneva Convention applies, and if so?
As to treaty obligations outside the Geneva Conventions, I don't think they're any part of the court's rationale. Geneva Conventions are discussed, and the question still remains as to what extent they apply in the case of persons who are enemy aliens but not necessarily prisoners of war in the traditional sense of fighting with an identifiable army. Identified by insignia, command, and
all it requires is the insignia, not necessarily a uniform.
Mm-hmm. Identifiable army that we don't have here as to whether the Geneva Conventions are applying or not. Now, Bush has said at various times that he will extend Geneva Convention rights, but that he doesn't have to. I dare say that will come before us and some other courts within the next 12 months. It is lurking in the background of the case my colleagues heard last week, pretty near the foreground, in fact, in that case, and certainly lurks in the background of the ones that we'll be having in the fall. So, yeah, that question is out there. You're identifying a very ripe question. Answering it is much harder than identifying it, but, yeah, that question is very much out there as to what the Geneva Convention implications are in the current unusual state of being at war. Anybody else? Scott, anything you want to correct?
No, Judge, I would never presume to correct you, sir.
Well, thank you very much.
Thank you very much.